Jeez, I need a haircut. Okay. Hey, what's up, Mad Cat? Dusted, how you doing, big? So, I'm gonna start doing these as you know, I know a lot of people subscribe to me because of you know, the gun rights thing, and obviously that's still gonna be a big. What's going on from Arkansas, Greg? That's my it's my Valentine's Day. Happy Valentine's Day, everybody. So, and I've got the AK-47 tie tack there. So, you know, much love for the AK. But in addition to gun type stuff, as I study here in law school, and one of the things I like to do is, since I'm here at law school essentially by myself and I have no life, any free time I have, I will pick a subject that is kind of relevant to what I want to fight for when I become an attorney, and start researching it. And one of the things, boy, you don't like, what's up? You don't like my heart tie? So what I'm going to do is I'm going to have a bunch of videos where I want to, you know, I know I'm going to be an attorney, and obviously attorneys to understand the law and be able to fight the system themselves. And I do plan to do a lot of pro bono work when I become an attorney, but I just want to help other people understand how the system works. I have a friend who is, and you know, access to justice is something you hear Democrats talk a lot about, but is really a big problem, and everyone should be talking about it. And yet, when you look at Texas, an attorney and has to fight something on their. I'm sorry, I'm in a very remote place. Let's just put it that way. You know, our Constitution talks a lot about due process, and so the thing I want to talk about today is, so I've got a friend, and this has happened to me as well, but I got a friend who I've been talking to who is dealing with a city issue where they're trying to charge him with some bogus Class C misdemeanor crime. And so I've been trying to help him, not give legal advice, I'm not allowed to do that, but try to help him on directing him where to go and kind of what to do to help. And they're really kind of screwing with him right now as it relates to evidence. And so today's video, I'm going to talk about the Code of Criminal Procedure, Section 3914, because I believe it really, and I'm going to tell you kind of why I think that statute is there, what the intent is, but also what the reality of that is, that has nothing to do with intent. And I think we can change that by amending that to meet the intent, but also not to screw people. Hey, Quint, when I'm done, you're going to have to say that again, because I can't scroll up, and I don't want to get distracted. But there's a case out of so from 1963. There's a case. It is in the description of the video. Brady v. Maryland, and in Brady v. Maryland, what it does is the Supreme Court held that it is a violation of due process for the prosecution to suppress evidence that the defense has requested and is material to either guilt or innocence. So we all know that they have to provide evidence constitutionally to support your innocence, but in Brady v. Maryland it also said guilt. So any evidence, it's a violation of due process for any evidence to be suppressed that the defense has requested and that is material to either guilt or punishment and favorable to the accused. So for both, okay? I know this all sounds legal mumbo jumbo, but this is very important, because at the end of this video, I want you to contact your state representative and any candidates that are going to be running in the election to try to become your state representative or your state senator. I've already contacted both of mine because 3914 needs to be changed. Here's what the practical matter is. What 3914 says, and I believe it's subsection E, is if you're a pro se litigant, that means if you can't afford an attorney and you're going to fight on your own behalf, you are going to be your own attorney and you're going to defend yourself, that the prosecution, when you submit a motion for discovery, yes, subsection E, when you submit a motion for discovery, the prosecution is not required to allow you to duplicate or copy that evidence if you're a pro se litigant, right? So if you're representing yourself, essentially what state law in Texas, and this is a Texas law, by the way, what state law in Texas says is if you can't afford an attorney, you don't get any evidence. Yeah, you can come look at it. You're entitled to look at it, but you can't take a picture of it. You can't get a certified copy of it. Now you can, but the prosecutors are not required by law to give it to you. This has got to change, and I'll tell you why. Because your only options are that you don't see the evidence until you get to trial, or you go there and apparently a better version, or you go there and you have to prepare your defense in front of the prosecutors in the prosecutor's office. So you have to go into hostile territory in order to prepare your defense if you're a pro se litigant. Whereas if you have an attorney, that attorney is provided all the evidence both against you and that can possibly lead to your innocence. So that's the problem that we have. And that's what's got to change. Now, here's why I think that is important. This is why I think the law, this is what the intent of the law is. The intent of the law is, so evidence, when you get evidence at a trial, you're not allowed to go out and just, post it everywhere. You're not allowed to give it to third parties and all that kind of stuff. You're not allowed to, because it can disrupt due process in the courts. And so attorneys are bound by a code of ethics, believe it or not, they're bound by a code of ethics, and they have to handle evidence in a certain way. And if the state is required to just hand over evidence to just anybody that's been charged with a crime, they can publish that information. That information can get out when it's not supposed to. It can affect the prosecutor's case. Blah 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 blah. That's what I think is one of, and it's a valid reason. But I also think that can be overcome through legislation, proper legislation. That, look, okay, you give the evidence to a pro se litigant, and I'm just going to say someone who represents himself. Okay. You give it to somebody who represents themselves, and they must sign an affidavit or whatever acknowledging that they cannot release this information publicly. They cannot give it to a third person who is not an attorney that is bound by contract to represent you in court, and essentially falls under the same rules as anybody else does. So I think that concern can be mitigated through legislation. The second reason that they probably have this law is that they don't want, for example, people who are representing themselves to potentially alter the evidence. And so they don't want to give it to them because they might alter it or change it or whatever. Well, again, that is something that can be mitigated through legislation that says that if evidence is given to a person representing themselves, a pro se litigant, then that they can only be given certified copies of that evidence. And what that means is, so the pro se litigant won't have the actual evidence, but they will have copies or duplicates or pictures of it, something like that. Now, if it's a physical object, generally the prosecutors keep all the physical objects anyway. So we're mostly talking about documents here. And it would be easy to see if a document has been altered because the certified copy will have a stamp on it. Obviously, the prosecutors will keep the original copy. So that's not really a good argument either. And even if it is a good argument, it can be mitigated by legislation that perhaps requires the evidence to be certified copied. The third thing might be, well, so attorneys, when you do a motion for discovery, like an attorney can't just request everything and anything under the sun. Attorneys are bound, again, by regulations and rules of evidence. And so, for example, let's say it's a speeding ticket, right? An attorney can't go and ask for the civil litigation records of someone else that's not even involved in the case. I mean, you can't just ask for evidence that isn't pertinent, and you can't just ask for stuff just to create havoc in the discovery process. And so that might be one of the reasons also that they don't allow pro se litigants or people who represent themselves to have access to the information. But again, the argument against that argument is, well, already right now as a pro se litigant, I can request anything in discovery. That doesn't mean they have to provide it all. They do have to justify why they don't provide something, but again, that can be just like there are rules for attorneys. There can be laws that pro se people who represent themselves have to abide by in requesting evidence. Okay, and you can also charge if you need copies or whatever. You can charge by the page, 20 cents a page or whatever. Obviously, it's got to be a reasonable cost. So, the final reason that I think this law is in effect, and it's one I can't argue against because I think it's probably the most likely reason, is that laws are written largely by whom? Who writes the? I mean, we know it's politicians, but what are most politicians? And I'm going to wait for a comment, see if somebody can figure this out. Who writes the laws? Who are the politicians that write the laws? I guess is the question. Well, not men. I'm not going into that. Tori, there you go. Mindbender got it. Lawyers, right? Lawyers are the ones that write these laws. They're the ones that become mostly. You'll find that most representatives are lawyers, and I think this was written essentially to force people to get an attorney so they can get access to evidence, and it's sort of a way to secure our own profession. That's why I really think 3914 is a law, because attorneys want to protect their own professions. And by golly, we can't have smart people who don't have attorneys going around doing our jobs. By golly, we spent 3 years of law school and $150,000 plus in debt to be able to come here and charge $150 to $450 an hour. We can't have people running around defending themselves, so we've got to put up obstacles. That's why I really think 3914 is out there. All right, so now that it's out there, we've got to overcome it. And the only way, so for example, my friend today he did a motion for discovery. He went down to the prosecutor's office, and they let him look at things, but he was not allowed to take a picture of anything. He was not allowed to get a photocopy of anything. He was not allowed to have any copy of it. They literally refused to give him the evidence. Now, they could not quote the law. They just said whoever he was talking to went back and allegedly probably spoke to either a clerk or the prosecutor and said, "I'm not allowed to give it to you." Well, that's not true. Prosecutors are allowed to give you the evidence because 3914 says that they're just not required to give you the evidence. So it's discretionary. Every prosecutor has discretion whether or not they give a person who's representing himself in a case access to copy evidence. That's got to change. This is what has got to change because it should be required. If you are defending yourself, you should be allowed to have access to the evidence in your trial, whether that evidence goes against you or that evidence is exculpatory and can help you. You should be entitled to have that, and you should not have to go to a prosecutor's office and literally write your defense while the prosecutor is sitting there watching you or the prosecutor's representative is sitting there watching you take notes because that's the only thing you can do is take notes. Now, if you wanted to sit there, you could probably write the evidence word for word, but you're not allowed to make a photocopy of it. You're not allowed to have a copy of it. And everything you do has to be right then and there. Whereas an attorney can just get copies of the stuff. So they make it harder for you as a person who's representing himself who cannot afford an attorney. They make it nearly impossible for you to be able to present an adequate defense because the law says they're not required. And what happens when you give government discretion on whether or not it wants to help you or hurt you? The government's going to hurt you. It's always going to choose the easy wrong over the hard right. What is the hard right? The hard right is going, well, I'm not required to give this information to you, but you know what? We're charging you with a crime, and you deserve the right and the ability to defend yourself on your terms. And so here's a certified copy. I need you to sign this form, this affidavit that says you will not provide it to a third party, that you will not publish in any way or make public any of this evidence, either for or against you, until after the court process is through with. Boom, you're done. That's how you fix it. That's what should be done. That's what good government would do. That's what non-tyrannical government would do to you. That's what an honest system would do to you. But I have heard and seen way too often, as I've seen and helped people go through court and try to do pro se litigation, even before I went to law school, because I've always defended myself in traffic court. And I've always done these motions for discovery, and I do my motions for continuance, and I do my motions to dismiss, and I've been doing all that kind of stuff for a long time. So I understand the process, and I think that's probably why most of the time when I do a motion for discovery, one, I know what I'm allowed to ask for, and two, I usually get it, because I think the prosecutors realize that I'm probably somebody that knows the system well enough anyway that I'm not going to be stupid with it. But we need to change that language. So this is what I want you to do. Okay. This is going to be a short video, but I wanted to let you know kind of what the process for discovery is in the state of Texas. And it is that if you can't afford an attorney, you're screwed. You have to figure this out. You've got to, you either don't get the evidence, and here's what happens. If you argue with them, like my buddy did today, they threaten to basically not even show it to you. And so your only option is you get to see the evidence when you get to trial or whatever, and then you have to ask for a continuance, because now that you've seen the evidence at trial, now you've got to prepare your defense. So you essentially wait for the prosecutors to present their case, and then you have to do a motion for continuance because, well, Your Honor, this is the first I've been able to see this evidence because the prosecutors held it from me because they didn't like the fact that I was asking questions and trying to get them to justify why they were keeping it from me. Yes, the law says that you can keep it from me, but all I wanted to know was why they were keeping it from me. So that's the issue that needs to change. So what I want you to do, if you're in Texas, is I want you to contact your representative and your senator, your state representative and your state senator. I don't give a shit about the federal government. I don't care about them. They're lost. And I want you to ask them to support and explain what the problem is with 3914, that it is biased and discriminatory against the poor and against people who can't afford an attorney, and decide, or you know what, as in my friend's case, it is such a crappy charge and it's such a bogus charge, and it's going to be so easy to get dismissed or to get acquitted on, because literally the evidence is not there. And by the way, I have evidence to show that you're wrong. But yet, because of that, and I'm defending myself because I don't want to pay an attorney to do what is extremely simple to do, which is defend myself in this particular matter, then it makes it hard. The law makes it hard. So ask your state rep or your senator to support a bill, and I'm going to help write this bill, and I'm going to submit it for the legislature next session. I think I've got a sponsor for it already. It just depends on what the language is going to be. And ask them to support the idea. Just ask them if they would support the idea of allowing defendants who are defending themselves without an attorney to have access to copies of evidence against them or for them. Okay, I know, and this might not sound like a big deal, but it needs to be changed so that the average person so that the average person can have access to the evidence against them so they can prepare a defense. It's very difficult to go down to the prosecutor's office, look at all the evidence against you, because you're going to have to take hours sitting there. First of all, you've got to make the appointment, right? You can't just go over it at any time. You're at the will of the prosecutors, of the government, when they're available to show you the evidence, because you don't have it in your possession. So you can't decide, okay, I'm going to work on it a little bit today. Maybe I'll work on it Friday night. Maybe I'll work on it Saturday morning. Maybe I'll work on it 2 days before trial. No, you have to go and look at the evidence when it's conducive to the prosecutor, when it's convenient for them. That's the problem with 3914. So I know this is like off left field, but it happened today with a friend of mine. It's happened to me in the past, where the prosecutors have refused to turn over evidence to me because they don't have to. And so I had to literally sit there and write everything down. They wouldn't let me take pictures of anything. And that's just got to change. I think that's an unfair system. It's biased against people who can't afford an attorney because they're poor, but they're probably not so poor that they can get a public attorney. And by the way, in most municipal courts for Class C issues, you're not allowed to have an attorney anyway. You don't qualify for an attorney for Class C. That's why you can't get a public attorney for a traffic case. That they will not provide you with a public attorney for a speeding ticket because it's a Class C misdemeanor. So now you can't get an attorney. You can't qualify for an attorney. And by the way, you don't get the evidence against you. So the system is stacked. We need to stack it back in our favor, in the favor of the people. So contact your rep, contact your senator, let them know this is a problem, ask them to support a bill that will force the state or the prosecution to give copies, certified copies, whatever it is, of evidence to a defendant, a pro se defendant. I've given you all the arguments. I even spoke with several of my law professors, and I said, hey, before I want to make a video about this, and I'm working on legislation to change this. This is a Texas law, so I know it doesn't affect y'all here, but what would be the arguments for keeping this law? What are the arguments against allowing defendants to have access to evidence? And though I actually came up with all the same arguments, because I said, here's what I think the arguments are. And I spoke to my professors, and they said the exact same thing. So apparently I'm going to be a great law professor one day. I don't know, because I was able to figure that out. So I've given you the arguments. Watch this video again to understand those arguments, so that when your legislator, who's probably once was a prosecutor, tries to argue and say, well, the reason we can't give evidence is because, we don't want the defendants going out there and altering the evidence and in their favor. Well, yeah, but we can also just make it to where they only get certified copies of it. We don't have to give them the originals. And then we know for a fact if it's been altered, and then we can charge them with fraud. There's laws for that. We can charge them with contempt. There's laws for that. So that's not a good argument. And then when they give you the other argument of, well, they can just ask for anything. Well, no, it's the same way it is right now. When I do a motion discovery, when I'm representing myself, I can't just ask for anything. So I've given you the arguments against it. The only real argument that they can come up with that they probably won't tell you about is that, well, look, if we make it easier for pro se litigants to defend themselves in court without an attorney, my gosh, I'll lose my job. I'll lose my $250 an hour. All right. There we go. All right, now I'm going to look at some comments here. So I think at the beginning of my video, I'm going to do this for about 5 minutes or less. I want this to be under 30 minutes. I'm going to see if you got any questions or anything. So if somebody brought something up at the beginning of the video that I missed because I was talking and I wanted to keep my thoughts in order, put it down here again. Check out Kirk's Law Corner on YouTube tonight, live show. Kirk's Law Corner. I will do that. As a matter of fact, tell you what I'm going to do right now is I'm going to look him up and subscribe to Kirk's Law Corner. Look at that. It's the first one that comes up when I type in Kirk. So, oh, look at that. Is he a Marine? Is he a former Marine? Oh, I guess you're never a former Marine, are you? Is he a Marine? Anyway, I subscribe to Kirk's Law Corner. All right, who's next? Thanks for the info, CJ. It's very interesting. One thing I've learned is that the legal world, yes, the legal world is much different than what I thought it was too. And it is my goal as I go through law school to try and help as many other people as possible to understand the law so that they don't have to go through this hell. Yes, Doc Green, right side of the mic. Don't forget to subscribe to Doc Green and right side of the mic. Go check those out. Yes, the government is very corrupt. Always a Marine, yeah. The government will always be corrupt. Yep. I mean, the whole premise of government, especially big government, is built upon corruption and keeping the little man down. All right, so let's see. Did Jim ask something here? Question: did you file a motion for submission of evidence? So Jim, yes, all the proper motions were filed. The problem is that Texas law specifically says that if you're a pro se litigant, that they are not required to give it to you. The only thing they're required, well, they're not even required to give it to you. They're just required to show it to you, is evidence that's exculpatory, that would lead to your innocence. So the problem isn't the motions, because the motions were filed. The problem is that the state law says even if you file the motion and you're a pro se litigant, you don't have an attorney, we're not required to give it to you. So the motion isn't the issue. The issue is the law. And the law needs to be changed. That's what I'm trying to do with this video, is get the law changed. Oh, good. Yeah. Doc Green is a great American. If you haven't heard his podcast, Doc Green is a great American. All right. He's the kind of radio host I can only hope to be. Yes, Brady v. Maryland. That's the case. And it's linked in the video description. At least it should be. So, the motion to suppress would only be if, see, it's really weird because you get a copy of the evidence. Well, you get to see the evidence. And according to the state, see, the problem is the Constitution isn't very clear on this, but, and Brady doesn't exactly cover whether or not they're actually supposed to physically give it to you. So in Brady, let me bring this up again, that it's a violation of due process for the prosecution to suppress evidence that the defense has requested that is material to guilt or punishment and favorable to the accused. What does that mean? What does it mean to suppress evidence? So if the prosecution shows it to you, but doesn't give it to you, legally have they suppressed the evidence? And I think that's the argument that is probably left open after the Brady v. Maryland case. And I haven't done a whole lot of research into whether I just know that the Brady case right now is controlling, so it hasn't been overturned, but I also don't know if there are Brady citations where Brady is referenced in other cases that actually, and this is something I'll probably have to go look at, that actually say, well, what Brady means is they have to give it to you, or they only have to show it to you. I didn't see in my quick scan of that case, because that's a controlling case for the issue specific to what I'm doing. So I've got to find out whether or not there are side cases that perhaps reference. I'm gonna have to do a shepherd eyes on that case and do a little more research into it. But regardless of what the case says, the law needs to be changed, because the law is the problem. And if the law is allowing the state to do this, then the law either needs to be changed or challenged constitutionally, and that's my next research project. So, yes, exactly. Yes. Right, Top Cat, Jim, that's what I'm saying. What does suppress mean? Does it mean they show it to you but they don't give it to you? Is that legally suppression? That's that's the issue that I think would be before the court. And I haven't been able to find whether or not that issue has even been brought up yet. What does suppression mean in the context of the Texas Code of Criminal Procedure, section 39.14? And this is all, to me, it's all interesting. I'm sure some people think it's boring legal crap. Yes, videos don't change laws. The courts and legislators do. Exactly. But I'm trying to explain to you what the issue is so that we can get the courts and the legislature to change the law. Okay. I'm at my 30-minute mark. I think I covered everything. It looks like I've got all the questions that everyone had. Yes, I do follow Chris Ann Hall. Follow her as well. All right. So the thing with Brady, the thing with Brady, Top Cat, I get that. Must. I only wrote down some notes from the case. I don't have the case actually in front of me I'll tell you what I'm going to do. I might do a recorded video that I'll upload later that talks a little bit more about Brady if there's a specific because I don't remember a specific section in Brady that said they have to give you the evidence. It just says they can't suppress it. My understanding was that they just couldn't suppress it because the prosecution didn't show them some of the statements. It says the defense saw several of the statements, but the prosecution withheld one in which another person admitted carrying out the killing. The court held that the prosecution's action, even though it had to do with punishment rather than guilt, denied Brady due process because they suppressed the document, not because they didn't give it to him, but they suppressed it. Obviously, he didn't have access to it, and it's a little bit... What is going on with my car? Uh-oh. Uh-oh. I think I'm going to have to... I accidentally left my car on. I might have to get a jump. Anyway. All right. That's all I've got. I will do a little more actual real study. Yeah. I'm going to look into that, Top Cat. I mean, I'm not disagreeing with you. The way that I read Brady when I read Brady and the way that I case briefed it, it was just about suppression of evidence, but it didn't say that the prosecution had to physically give you everything, like give it to you. And what's different about Brady versus a pro se case is that Brady had an attorney, and they actually suppressed, so they have to give it to an attorney. But this is a pro se case, so it actually, Brady might even be somewhat distinguished on that particular point, but it still states that you can't. Whatever. All right, I will do that. All right, guys, y'all take care. Be safe. Be free. And by the way, if there's an issue of law that you'd like me to cover on a future video, if I have the time, send me an email, cj@cjgrisham.com. And if it's something you're interested or something you want explained, I will do my best. I love research. I love legal research. And so when I do have free time here, instead of screwing around, I actually go in there and try to figure out something that I think is going to be an issue when I get back to Texas that I'm probably going to want to fight for as an attorney. So I'm like preloading all my arguments for future cases. That's my hope. All right, guys, take care. Be safe. Be free. Don't forget to like and subscribe, please, and share this video and contact your representatives. Out.